Al Henshaw here again for the Constitutional Crisis channel. Today's subject, for those of you who've been following the videos, is not a new one. Donald Trump, yet again, and the NRA, gun control. Are they right? The short answer, just as it was before, is yes, but not for the reasons they think and that they advocate. The Second Amendment is not an issue and hasn't been since Presser v. Illinois, 116 U.S. 252 in 1885. Any attorney worth his salt knows this, and anyone that's a proponent of the Second Amendment at this late date, in my view, has an alternative and likely secret agenda to keep the issue going so as to keep their organization going. That's the only thing you can think. It's not unlike advocates of civil rights for the same reason, that once the civil rights issues either get resolved or struck down, if I get my way in the Supreme Court, the 14th Amendment doesn't exist, their raison d'etre, their reason for existence, ceases to exist along with it. So the people running these organizations, the power behind them, for the most part, don't want any answers. They want just the opposite, and this is one of the big problems we have. Nevertheless, that said, the Second Amendment does not apply to the states. I've mentioned this before in several of my videos. There's no possible way it can, and that goes back to the key case of Barron, B-A-R-R-O-N, versus City of Baltimore, 7 Peters 243, I believe it's 32 U.S. 243. You can check the sites, by the way, in the note to this at the bottom. They'll be there. For some reason I'm off a little bit. They'll be correctly there. So that said, it's much easier to take care of. What you do is you go in and cite, in my view, Article 1, Section 9 or 10 of the Constitution of the United States that deals with prohibitions on bills of attainder. That's the taking of property without judicial process. The Supreme Court has said more than once that judicial process has to be construed as understood by the framers of the Constitution. That's the only way that you can do that, because it hasn't been amended, there's been no changes. And that judicial process, by definition, means, according to the course of the common law, and with the trial by jury. And all this is laid out in the Northwest Ordinance of 1787 in Article 2. We are, frankly, much better off to claim to be inhabitants of a territory than we are to claim to be citizens of states, especially when these states don't exist. You can see the problem. You'd much rather be in a territory than you would a state, which makes no sense. The framers would not comprehend that at all, but then they couldn't possibly have conceived the amount of treason and deceit that's gone on, in the past 225 years. But that's where I have the dead bang proof of it. I mean, it's not even arguable anymore. And that's how we're going to win. That's how we're going to beat these bastards. Now, on the same subject, and almost at the same time, Hillary Clinton rings in on this same subject, and she takes the position, if it can't be resolved, quote unquote, by legislative action, then executive action is called for. That can only mean an executive order issued by the president, acting in capacity of the commander-in-chief of the armed forces. And that's exactly what they can do in a territory, but not a state. But even then, Congress's powers are limited in territories, and whatever power they've delegated to the president must also be likewise delegated. And again, Article 1, Section 9 talks about limitations in the territories. So they're going to have some serious problems there, whatever they do. And guns, after all, once they reach, the old-time rule with Commerce Clause powers was, once the guns or whatever it was arrived from the manufacturer and it got to the retail store, that was the dead end for interstate commerce. Now it goes into the flow of intrastate commerce. That's a case called ALA Schechter Poultry, S-C-H-E-C-H-T-E-R, 295 U.S. 495, and it's one of the best decisions the court ever made, 9-0 against FDR, and one of the main reasons for his later court packing plan that came up. But that was the definition up until that time. So this is intrastate commerce, and Congress has no authority whatever to deal with that. However, since FDR and since NLRB versus Jones and Laughlin Steel, that's 301 U.S. 1, the definition now basically includes everything under the sun that's subject to the Commerce Clause powers of Congress. And those, again, as a reminder, and I've said this before, are closely associated with the Admiralty jurisdiction. Can't be. Not when the Admiralty jurisdiction was the principal cause of the American Revolution. Just a little reason, logic, and common sense here. something they do not specialize in the mandatory public school system, would tell you that if they bothered to tell you all these facts. If you hit you like a ton of bricks, you'd figure it right out. Well, that's what's going on here. And that's what has to stop. So you get these idiots like Clinton. I mean, we've already had 8 years of that family in the White House. Why would we want to have 8 more? That's anybody's guess. Not that there are any good candidates, and not that there are any valid elections. We're not talking about that here either. But that said, that lets the cat out of the bag as to what politicians on both sides think the ultimate solution is. The Republicans would be just as quick to do this, I think, as Hillary Clinton would. Issue executive orders to take care of it. That's not how we're supposed to be creating laws here. Plain and simple. Now, the sooner we quit doing it, no matter what the context, the better we're going to be. If you go outside the Constitution, and if you can do that in one case, why can't you do it in all of them? I mean, there's no limit upon that kind of power. And if you want to read a really great case about this, read the opinion of Roger Bruchtani in a case called Ex Parte Merryman, which I believe is 17 federal cases, 245. I'll have the site for you on this one exactly in the notes below. You can Google this one too, and even as an old case, it's going to pop right up. Read this decision closely. You won't believe what he said. This is one of the things for which he was considered, to be a bad justice and a bad chief justice, in addition to the Dred Scott case, which had been decided a few years earlier. But you read this opinion where he says that Lincoln has no right to suspend the writ of habeas corpus, which is what was done in the case of Merryman in 1861, just as the war between the states was breaking out. You read this and you compare it to these idiotic statements by Clinton and by Trump, and you see where the law of the land really is. It's going to wake a few people up, and I think in an area with gun control, it's going to get some serious attention here. Because if we don't have guns, all you have to do in history is go back to 1938. Look what happened in the Sudetenland when Hitler disarmed the Czechs. Bang, they were out there in about a year. Peace in our time, according to then Prime Minister Neville Chamberlain, who conceded all this crap. I mean, this is what happens when you get rid of guns. Then only the criminals have guns. I mean, that's a fairly simple equation, one would assume. Okay, that said, there's going to be much more to say about this later as I get some more thoughts and things together. But if you read these, you're going to see these are dead-on spot authorities I'm giving you. There's no arguing about this. And you should tell people that advocate the Second Amendment that, I'm 100% right, they're wrong, and that they should quit doing it. You'll get a hell of a lot farther and a hell of a lot faster if you do that. Thank you.